This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, province, county, city, township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. One last time, this meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in appropriate manner to eliminate all conflict and false allegations. Is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of the federal, state, province, county, city, township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. All clear, so I'll open up our meeting with a short prayer. O Holy Father, bless our meeting with eyes to see and ears to hear the messages and info being presented with an open and caring and compassionate heart for our fellow brothers and sisters, as it shall be done. Take it away, Glenn.
Thank you, Lori, and well said. Just in case nobody heard what we talked about earlier, I got a docketing letter. I've uploaded it to my private group on WeRLaw, to my page. The significance of that is that the Supreme Court gets about 5,000 cases every year, and they accept about 5%. It says right in the rules they can turn any case away they want. And so, and if they don't accept it, then it doesn't get docketed. And so we should probably go through the docketing letter too. Maybe I'll do that. But anyway, so this was what I filed. Okay, I went back and forth several times, probably 5 or 6 times, I think. The clerks are quite helpful. And so every time, they would say, make these changes, and I'd make the changes and send it back. And they'd say, well, some changes still need to be made. One of the issues is that they wanted I had originally had there's got to be a statement about why the writ should be allowed. And I had it in there, but I didn't have it in the table of contents. And so then the next time I moved it up to the front, and they said it should be at the back. That was the next time they sent it to me. The statement should be at the back. Anyway, so what I did is I put it in the table of contents, and that ended my trouble. So it went back and forth for a bunch of reasons, and finally I got this docketing letter. And so docketing letter means that the Supreme Court has accepted it. It's on the docket. And so this is, if you do the informa pauperis thing, then you only have to send an original and 10 copies of the petition. Now, the whole thing is 334 pages with my appendix and attachments and everything. And so 10 copies is a lot of copies, that's 3,500 copies. So that can get expensive. And then you have to serve it on all the respondents. And I had 7 people that I had to serve it on. So now it's 17 copies. And so if you don't pay the filing fee, then you have to do that. If you pay the filing fee, you have to send them 40 copies. And so now you're talking, and then the shipping for all of that, I mean, it gets pretty expensive. They say that when you go to the Supreme Court, that it's going to cost you $2 million, and that's probably about right. And that's most of that is for the lawyers. Anyways, so if there's any victory here, it's the fact that Montague County is going to have to go out and spend $2 million on lawyers now. So, anyways, break it off in their ass. So I started off. This is how I got out of filing the this is the Informa Pauperis, okay, form. This is a standard form they give you in the Supreme Court, and you fill it out. And so I sign everything in red ink. So they give you this questionnaire. It's an interrogatory, okay? That's what it is. And an interrogatory is something they use in a civil lawsuit, and it's asking a bunch of information that's really none of their damn business. And it's a violation of your rights. And so we'll go through how I dealt with that. But so this is what the way I dealt with this one. I put NA in all the blocks. You can see that. Spouse, child support. See
I like
declaration.
the NA.
See
Not
that.
applicable. Not applicable.
See declaration in support of Informa Pauperis interrogatory attached. And they want to know employment history for the last 2 years. I just put NA. See declaration in support of Informa Pauperis interrogatory attached, all of which is incorporated herein by reference in its entirety. And here's more. I just put NA. If you put anything in there, you're giving information against yourself. So I wouldn't put anything as just a matter of principle. You know, one time I put in someone owing me, I put United States owes me $2 billion. Didn't help. Anyways, see declaration of Informa in support of Informa Pauperis interrogatory attached. Then they want to know transportation and all of these commercial words, okay? Motor vehicle. These are all commercial words. Taxes, installment pays, credit cards, department stores. These are all commercial words. You got to understand that. And so, you know, you'll see in my a declaration how I deal with that. And I just put down NA and everything. See declaration in support of Informa Pauperis interrogatory attached, all of which is incorporated herein by reference in its entirety. Now, this is the declaration in support of Informa Pauperis interrogatory. I, GlennWinningham, House of Fern, hereby affirm the following. I have first-hand knowledge of this matter. All the facts stated herein are true, correct, complete, not hearsay, not misleading, but are admissible as evidence, if not rebutted and proven inaccurate, and if testifying, I shall so state. I have standing capacity to act in the lawful matters herein, and I have personal, executive, and documented knowledge of the facts stated herein. These are all just standard stuff you put up at the beginning of the affidavit. I'm competent in this matter. I have no first-hand knowledge of a date of birth. Now, you got to give them something, okay? Because they got to know that you're over 18. Okay, you got to do something to say that you're over 18. So this is how I deal with it. I have no first-hand knowledge of a date of birth, but I do remember finishing high school in 1975, over 50 years ago. Therefore, I'm well past the age of majority. And then the power to create presumptions is not a means of escape from constitutional restrictions. Bailey versus Alabama. An unconstitutional law fails to be law, confers no rights, imposes no duties, affords no protection. And their requirement for all of this crap is unconstitutional. In the absence of the evidence to the contrary, I'm the free man on the soil of Texas and other American states from time to time, and devoid of any knowledge of surrendering or volunteering myself as a government employee or to the armed forces of any country, and hold any respondents to the strictest proof to the contrary. In the absence of evidence to the contrary, I'm not dead or lost at sea, and hold any respondents to the strictest proof to the contrary. In the absence of evidence to the contrary, I've never been dead or lost at sea, and hold any respondents to the strictest proof to the contrary. In the evidence to the contrary, I'm not the Pope's minor estate, 31 CFR 363.6, and hold any respondents to the strictest proof to the contrary. In the absence of any evidence to the contrary, I'm not representing the Pope's minor estate, and hold any respondents to the strictest proof to the contrary. In the absence of evidence to the contrary, I'm not a surety or in any way an accommodation party for the Pope's minor estate, and hold any respondents to the strictest proof to the contrary. In the absence of evidence to the contrary, I've never willfully represented the Pope's minor estate, and hold any respondents to the strictest proof to the contrary. In the absence of any evidence to the contrary, I want nothing to do with the Pope's minor estate or the fake money in his Treasury Direct account. Maybe somebody can shove it up the Pope's rectal orifice, and hold any respondents to the strictest proof to the contrary. I will gladly complete the informis properis interrogatory when this court provides an authentic order as required by the Authentications Act of 1792, 1 Stat 122, signed by a judge operating in his official capacity with a court seal, that orders me to surrender my Article 5 and Amendment right to fail to give evidence against myself in order to exercise my right, my Article 1 and Amendment right, to seek a redress of grievances. And there's lots of Supreme Court cases that say that they can't make you give up one right to assert another. B, this court provides their statutory and delegated authority to convert my Article 1 and Amendment right to seek a redress of grievances into a privilege. That's what the filing fee is doing. Think about it. Converting a right into a privilege. This court provides an authentic order as required by the Authentications Act of 1792 at 1 Stat 122, signed by a judge acting in his official capacity with the court seal on it, ordering me to 1. Agree to work for the Pope's unconstitutional 1871 Ecclesiastical Roman Canon Law Municipal Corporation at 16 Stat 419 as an employee. And this is two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. 2, get 2 forms of government identification. 3, agree to be subject to the Pope's Roman Canon Law by applying for and getting a Social Security number. 4, agree to be subject to the Pope's Roman Canon Law of negotiable instruments by getting a bank account, which is, and this is the Gold Reserve Act of 1934, and so Federal Reserve notes, the term United States means government of the United States. The term currency of the United States means currency is legal tender in the government of the United States, and includes United States notes, Treasury notes, gold certificates, silver certificates, Federal Reserve notes, all that stuff, okay? So, and that's the Gold Reserve Act of 1934, which is codified at 12 U.S.C. 411. And Federal Reserve notes to be issued at the discretion of the board governors of the Federal Reserve System for the purpose of making advance for the Federal Reserve banks through their Federal Reserve agents as set forth here, and for no other purpose are authorized. 5, agree, contrary to my sincerely held Christian religious beliefs, to participate in the Pope's satanic lies, fraud, deception, necromancy, idolatry, and human trafficking under Roman common law. And 6, describe the girl to whom I'm joined in holy matrimony as a spouse. 7, describe my property as assets. 8, describe my sons and daughters as children and dependents. 9, describe my source of compensation for labor as my employer and employment. 10, describe my private automobile as a motor vehicle. 11, describe my compensation for labor as gross monthly pay and income. 12, describe the land I own as an asset and real estate. 13, describe my traveling as transportation. 14, describe my home as a legal residence. 15, describe the fake money, Federal Reserve notes I use to set off debts with as money. 16, describe the fake money I spend as expenses. 17, describe the hearsay evidence of a date of birth, of a birth date as a date of birth as if it's a fact, for their informa pauperis interrogatory, all of which falls under the Pope's Roman canon law. And D, this court provides an authentic Article 4 Amendment warrant as required by the Authentications Act of 1792, 1 Stat 122, signed by a judge acting in his official capacity with a court seal that orders me to disclose all or part of a Social Security number, disclose financial institutions, disclose income, disclose spouse income, disclose gifts, disclose spouse gifts, disclose retirement income, disclose other income, disclose my age, disclose employment history, disclose spouse employment history, disclose employer address, disclose expenses, disclose assets, disclose real estate. Just a second, I'm checking. Yep, I just want to make sure it's going good on the YouTube. Disclose anything else that's required to be disclosed and calling it out specifically what's required to be disclosed as required by Article 4 Amendment for the informa pauperis interrogatory. I, GlennWinningham, House of Fern, demandant sui juris, natural living man living in the Republic that fails to be dead or lost at sea, has never been dead or lost at sea, fails to be a surety or accommodation party for the Pope's minor estate, 31 CFR 363.6, that fails to represent the Pope's minor estate, 31 CFR 363.6, have never knowingly or willfully represented the Pope's minor estate, 31 CFR 363.6, and do declare that I ascribed and read the foregoing facts in accordance with my best first-hand knowledge, such are true, correct, complete, not misleading, the truth, the whole truth, and nothing but the truth, before God, angels, and anyone who reads this document as witnesses and pursuant to your rules of evidence. Notice I call it their rules of evidence. Sign and seal in red ink under penalty of perjury without the Pope's United States. And it's got all that stuff there too. And that's it. That's my certificate of service. I served an original with the Supreme Court. That's all you have to do. You never send this kind of stuff to the opposing parties. It's none of their business. So,
it's published at the Supreme Court, though.
Sorry?
It's published at the Supreme Court.
I don't know if it is or not. I don't believe it is.
It is. It's for the public record.
Well, that's interesting.
Look at the docketing. When they docket it, it'll be on there.
Make sure you ask them the question about why your response was important to be in the docket, the trial docket at the beginning at one point of time and then at the end at another point of time. What was the relevance for that? Well, you said that they sent it back to you because they wanted your explanation put at the front of the docket or your package, I guess.
I guess I could put that in there, but that'd just get the clerk in trouble. And actually, I appreciate the clerk's help, so I don't want to do that.
Okay.
Anyways, and besides, the clerk was probably they were probably helping me, trying to help me to get it ready. And eventually it got accepted and it's docketed now. I mean, shoot, that's what you want, Anyways, something else, Lori?
No, I was just wondering now, do you have to watch the website to see when it's going to be set to be heard, or
no?
When do you get it?
No. They'll send something. If I get anything, it'll come in the mail. I'll show you why here in a minute. It's quite interesting because they want all the lawyers have to do electronic filing, but I don't. Okay, I'll be doing it all paper, and I'll show you how that works. Anyways, all the lawyers have to do it. But I was talking to this lawyer today, and he said that I'd probably have to go for oral arguments, and so that ought to be interesting. I wasn't expecting to have to go to oral arguments because a couple years ago or 3 years ago there was a public statement by the Supreme Court saying that only lawyers would be authorized to do oral arguments. So I guess we'll see. But we're going to go through. Actually, maybe we'll go through the docketing. No, we'll go through this first. This is the actual petition for writ of certiorari that I filed.
You can what you do is you petition for pro hac vici.
A what?
Pro hac vici. You petition to the court to be pro hac vici.
I don't know what is that?
Becoming a member of the court to argue in it. That would be pro hac vici.
Never heard of that. I'm not sure.
Yeah, just look it up.
Is that what the Supreme Court does? Is that something the Supreme?
Yeah, that is, and they'll give you, because they docketed mine too, and then they'll give you a. I did a petition for expedited hearing, and so they granted that. But there was they docketed it, and then they set it for conference like within 30 days. But then if they request, what you do is you request to be admitted pro hac vici, and that's a friend of the court to argue in the court. They allow that for pro se litigants if you want to do oral arguments.
Well, I appreciate that. But I don't particularly want to do oral arguments, quite frankly. I mean, I would if they want me to, but I don't see why I need to. I think the document speaks for itself, and so I don't see why I need to. But anyways, I appreciate that input. That's very interesting. I was completely unaware of that. Anyways, so let's keep moving here. This is the actual petition that I signed. They actually, one of the complaints that the clerk had is that the respondents listed were, like, a bunch of them got removed by the Court of Appeals. And so the respondents listed, I listed them all, and the clerk said that wasn't the right respondents. So what I did is I put down exactly what the Court of Appeals put down, which is what's here, and they accepted it like that. So anyways, so this is the front cover, and then the first thing that they see is the questions for review. And I think this is important because this sets the tone of the case. This brings up the issues that need to be looked at. Anyways, number one, is the 1871 Municipal Corporation at 16 Stat 419 a law made by Congress respecting an establishment of religion and an unconstitutional violation of Article 1 and Amendment because it comes from what is now the Vatican and introduces the Pope's Roman canon law into the United States of America? Question number two, is the minor estate at 31 CFR 363.6 a law made by Congress respecting an establishment of religion and an unconstitutional violation of Article 1 and Amendment because it was created by the Pope's owned and operated Crown of England with the Sestake V Act of 1666 and brought into the United States with the Code of Law for the District of Columbia in 1901 at 31 Stat 1432. Question number three, is the National Bar Foundation, Title 35, USC 70501 through 70512, and all of its subsidiaries in the various states, a law made by Congress respecting an establishment of religion and an unconstitutional violation of Article 1 and Amendment, because it is bringing the Pope's private bar guild, British accredited Regency, into the United States, which originated in the Pope's owned and operated City of London, and they're claiming immunity under the International Organization Immunities Act of 1945 at 59 Stat 669. Question number four, Is the National Bar Foundation, Title 35, USC 70501 through 70512, and all its subsidiaries in the various states, a violation of Article 1 of the Definitive Treaty of Peace of 1783, which is the only article still in force under the treaty collection, which is the supreme law of the land under Article 6, Clause 2, because King George approved the Definitive Treaty of Peace of 1783 as Arch-Treasurer and Prince-Elector of the Holy Roman Empire, evidencing he was approving it on behalf of the Pope, and because King George and the Popes owned and operated Crown of England, for himself, his heirs, and successors relinquishes all claims to the government propriety. Because propriety is talking about private businesses, which includes the bar. I'll tell you, I think I got the bar one way or the other. They're done. Is the minor estate, 31 CFR 363.6, a violation of the organic law of the Declaration of Independence? He's combined with others, subjecting us to the jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, for imposing taxes on us without our consent, which is referencing the Pope and his Sister KB Act of 1666 as the reason for the War of Independence. Is it an unconstitutional violation of Article 1, Section 8, Clause 17, to use the minor estate, 31 CFR 363.6, and the Commerce Clause, Article 1, Section 8, Clause 3, to convert the petitioner's land from the land of Texas into the foreign District of Columbia, when there's no evidence over Roman canon law commercial activity, and no contract, as evidenced by the fact that silver coin was converted to land, and it was demanded to produce a bona fide contract with no response of any kind? Is a judgment by the 97th District Court, which makes the petitioner a minor estate, 31 CFR 363.6, a bill of pains and penalties, violation of the Bill of Attainder clauses, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, and that's it. Yeah, is a judgment that makes the petitioner a minor estate a bill of pains and penalties, violation of the Bill of Attainder clauses. Is a judgment by the 97th District Court that makes the petitioner a minor estate, 31 CFR 363.6, by presuming incapacity without adjudication, a denial of due process of law under Article 5 and Amendment, or a violation of the Equal Protection Clause in Article 4, Section 2, Clause 1. So what was happening is I wanted to keep this down to 17 questions, because 17 is the number of the book of Esther in the Bible. It's the number of Q. And so I wanted to keep it down to that. So I was having to scrunch these together. Otherwise, I could have easily stretched it out. I made, probably 4 or 5 more questions. Anyway, so that's why I consolidated under a violation, a denial of due process of law under Article 5 and Amendment, or a violation of the Equal Protection Clause in Article 4, Section 2, Clause 1. Is a judgment by the Northern District of Texas that makes the petitioner a minor estate and an unconstitutional bill of pains and penalties in violation of the Bill of Attainder clauses, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. Is a judgment by the Northern District of Texas that makes the petitioner a minor estate, 31 CFR 363.6, by presuming incapacity without adjudication, a denial of due process of law under Article 5 and Amendment, or a violation of the Equal Protection Clause under Article 4, Section 2, Clause 1. Is the refusal by the Federal Bureau of Investigation to investigate 78 criminal complaints and a denial of due process of law under Article 5 and Amendment? Is the refusal by the Federal Bureau of Investigation to investigate the 78 criminal complaints a violation of the Equal Protection Clause under Article 4, Section 2, Clause 1? Is the refusal by the U.S. Attorney to prosecute the 78 criminal complaints a denial of due process of law under Article 5 and Amendment, or a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1? Is it an unconstitutional violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, for the bar member controller of Texas to authorize the County of Montague Municipal Corporation to make the petitioner a minor estate, 31 CFR 363.6, to render by force the petitioner's land for taxation, to justify the theft of the petitioner's land, to extort fake money in support of their communist agenda, to eliminate private property rights, because the petitioner is a targeted individual, as evidenced by the targetedjustice.com website. Is the forced rendition of the petitioner's land for taxation by the County of Montague Municipal Corporation in conspiracy with the bar member controller of Texas a violation of the organic law of the Declaration of Independence? He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation for imposing taxes on us without our consent, which is referencing the Pope and his Sister KV Act of 1666 as the reason for the War of Independence. Is the findings, conclusions, and recommendations of the United States Magistrate Judge, which fails to be a findings of facts and conclusions of law, a legislative usurpation of the bench because it's involving a fiction of law, which fails to exist under the Pope's ecclesiastical law, penalizing the petitioner, a named individual, with a non-judicial theft of land, and a bill of pains and penalties violation of the Bill of Attainder clauses, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. Is the findings, conclusions, and recommendation of the United States Magistrate Judge, which fails to be a findings of facts and conclusions of law, a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, or a denial of due process of law in violation of Article 5 and Amendment by presuming incapacity without adjudication? That's the 17th question, so they had to end there. See, I could have stretched it out, probably added in another 10 questions, and using those same statements in there. Anyways, okay, so then we have the table of contents. See here, reasons for granting the writ. I put that in there just for the clerk. Table of authorities. Summary of the case. The petitioner converted silver to land on the land of Texas in 2021 and stated on the face of the deed that the petitioner failed to be assessed a K trust, a true copy of which is attached to the notice of objection to the findings and conclusions of the magistrate judge and motion to reconsider that's attached here too in the appendix at tab 4, pages 111 to 112, all of which is incorporated herein by reference in its entirety. The County of Montague Appraisal District Municipal Corporation, under the direction of the Texas Comptroller and in conspiracy with the bar members, converted the petitioner's land from the land of Texas to the Foreign District of Columbia under the Commerce Clause, Article 1, Section 8, Clause 3, to render by force the petitioner's land, as evidenced by the General Real Property Rendition of Taxable Property, Form 50-141, that's attached to the notice of objection to the findings and conclusions of the magistrate judge and motion to reconsider, that's attached here too in the appendix at tab 4, pages 113 to 114, all of which is incorporated herein by reference in its entirety. The County of Montague Municipal Corporation enslaved the petitioner with their minor estate, with their tax notices and tax liens and threat letters, as evidenced by the delinquent tax statement that's attached to the Catherine Phillips notice and demand, that's attached to the notice of objection to the findings and conclusions of the magistrate judge and motion to reconsider, which is attached here to in the appendix at tab 4, pages 92 through 110, all of which is incorporated herein by reference in its entirety. The petitioner served by registered mail a Catherine Phillips notice and demand to officials of the County of Montague Roman Canon Law Municipal Corporation, explaining that they were engaged in multiple felonies and that the petitioner failed to be assessed a K trust, and demanding that they produce a bona fide contract. In paragraph 43 at tab 4, page 103 and 104, quote, "And this notice and demand shall be evidence of your intent to engage in all the crimes, including but not limited to those described herein, and it shall be further evidence that Clay V. Riddle, Kim Jones, and Jennifer Finoglio and others intend to be your accomplices and co-conspirators, as well as your agreement that I file criminal complaints against all of you and bar grievances against all bar members in your private capacity and seek other remedies." a true copy of which is attached to the notice of objection and findings and conclusions of the magistrate judge and motion to reconsider that's attached here too in the appendix at tab 4, pages 92 through 110, all of which is incorporated herein by reference in its entirety. The County of Montague Municipal Corporation got their bar members to file a tax suit on behalf of the Bowie Independent School District in the 97th District Court before Patricia Coleman Byers, as evidenced by the judgment that's attached to the notice of objection to the findings and conclusions of the magistrate judge and motion to reconsider that's attached here too in the appendix at tab 4, pages 115 to 117, all of which is incorporated herein by reference in its entirety. The petitioner filed 78 criminal complaints into the case and sent them to the Federal Bureau of Investigation and the United States Attorney, and the weaponized Department of Justice ignored them, and the fake judge ignored them, as evidenced by the demand to disqualify the judge, a true copy of which is attached here too in the appendix at tab 1, all of which is incorporated herein by reference in its entirety. The petitioner filed a petition for a writ of mandamus for the Second Court of Appeals to order the lower court to prove standing in jurisdiction, and the Second Court of Appeals refused to accept it because the petitioner is a vexatious litigant, as evidencing their intent to deny the petitioner due process of law, as evidenced by the clerk's letters, true copies of which are attached here too in the appendix at tab 2, all of each of which are incorporated herein by reference in their entirety. The petitioner brought the case to a common law jury. Our one Supreme Court talked about in Article 3, Section 1, the judicial power of the United States shall be vested in one Supreme Court, which issued an affidavit of findings and facts, a true copy of which is attached in the appendix at tab 12. The 97th District Court subjected the petitioner to their star chamber with their forced legal counsel and their refusal of a challenge to jurisdiction, pages 118 to 135, as evidenced by their return mail at pages 137 to 138, and issued a bill of pains and penalties similar to a bill of attainder with their legislative act against the petitioner named individual, made the petitioner the Pope's minor estate to justify the theft of the petitioner's land by the County of Montague and their bar member handlers, and enslaved the petitioner for their Vatican handlers at pages 115 to 117, and they're in the process of unlawfully selling the petitioner's land when on the day of the sale, the petitioner set off their extortion with Federal Reserve note commercial paper, fake money, that are only for use in the Pope's foreign-owned and operated Roman canon law municipal corporation in the District of Columbia. And this Gold Reserve Act of 1934, evidencing that they were the second national government talked about in the dissenting opinion of Downs versus Bidwell, maintained by Congress outside and independently of that instrument. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. All of which is evidenced by the returned challenge to jurisdiction and attorney's fees ordered on page 141 that's attached to the Catherine Phillips notice and demand, that's attached to the notice of objection to the findings and conclusions of the magistrate judge, motion to reconsider, that's attached to the appendix at tab 4. All of which is incorporated herein by reference in its entirety. The petitioner has never in his life breached the peace, but the weaponized Federal Bureau of Investigation military police refused to investigate the felonies, and the weaponized United States Attorney refused to prosecute the felonies, and the County of Montague Roman canon law municipal corporation and conspiracy with bar members had engaged in support of their weaponized Department of Justice and their communist handlers to implement the first plank of the Communist Manifesto, the abolition of private property rights. All this originated with the Roman canon law municipal corporation established by Congress at 16 Stat 419 that's now owned and operated by the Pope. The petitioner filed a lawsuit in Fort Worth Federal Court, and they issued a findings, conclusions, recommendations of the magistrate judge, which is attached here too in the appendix at tab 3, which fails to be the required findings of fact and conclusions of law, which means it has nothing to do with facts or law, which means that they were legislating from the bench, and it was a bill of pains and penalties, which is a bill of attainder violation under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. True copy of which is attached here too in the appendix at tab 3. The petitioner filed document 104, notice of objection to the magistrate judge's findings, conclusions, recommendations, and motion to reconsider, filed 15 February 2025, a true copy of which is attached here too in the appendix at tab 4. The court filed an order accepting findings, conclusions, recommendations of the United States Magistrate Judge, filed 21 February 2025, true copy of which is attached here too in the appendix at tab 5. The court filed a final judgment 21 February 2025, a true copy of which is attached here too in the appendix at tab 6. The petitioner filed a notice of appeal on 3rd March 2025 with the U.S. Court of Appeals for the Fifth Circuit, case 25-10360, true copy of which is attached here too in the appendix at tab 7. The petitioner filed document 108, notice of constitutional challenge, filed 10 March 2025 because they were obviously making the petitioner for their minor estate, and it failed to matter what the petitioner said or did, a true copy of which is attached here too in the appendix at tab 8. The petitioner filed document 112, mandatory judicial notice of 12 presumptions, because they're obviously making the petitioner their minor estate, and it failed to matter what the petitioner said or did, filed 30th May 2025, a certified copy which is attached here too in the appendix at tab 9. The petitioner filed document 113, affidavit of life, filed 30th of May 2025, because they're obviously making the petitioner their minor estate, and it failed to matter what the petitioner said or did. Certified copy of which is attached here too in the appendix at tab 10. The petitioner filed document 114, a notice of void judgment, 30th of May 2025, a true copy of which is attached here too in the appendix at tab 11. The U.S. Court of Appeals for the Fifth Circuit affirmed the decision of the District Court on 14th of November 2025, a true copy of which is attached here too in the appendix at tab 13. Statement of jurisdiction. This petition for writ of certiorari is brought pursuant to 28 U.S.C. 1254 as an appeal from the U.S. Court of Appeals for the Fifth Circuit dated 14 November 2025. The petitioner is also invoking the original and exclusive jurisdiction pursuant to 28 U.S.C. 1251 because the petitioner's posterity is found in the preamble, because Will Livingston ratified the Constitution for New Jersey, 1781, is the petitioner's fourth great uncle, which makes this an action between the petitioner as one of we the people of Texas State and the state of Texas, which is a controversy between the states. Constitutional and statutory issues involved. The 1871 municipal corporation created by Congress at 16 Stat 419, the minor estate, 31 CFR 363.6, and the foundation of the Federal Bar Association under the Code of Law for the District of Columbia, now known as Title 35, USC 70501 through 70512, are each unconstitutional violations of Article 1 and Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because they are each laws respecting the Pope and the Vatican and the Holy See, and they're also because they're busy subjecting the petitioner and the people of this country to the Roman canon satanic religious ceremony with their fraud, deception, lies, idolatry, necromancy, in violation of sincerely held Christian religious beliefs. The foundation of the Federal Bar Association under the Code of Law for the District of Columbia, now known as Title 35, USC 70501 through 70512, is also a violation of Article 1 of the Definitive Treaty of Peace of 1783, which is the only article still in effect under the treaty collection, which makes it the supreme law of the land under Article 6, Clause 2, and therefore a constitutional violation. The judgment of the 97th District Court, as well as the judgment of the Northern District of Texas, are each a bill of pains and penalties, are prohibited under the Bills of Attainder clauses of the U.S. Constitution, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. They're bringing the District of Columbia outside a maximum 10-mile square in violation of Article 1, Section 8, Clause 17. Statement of the case. The petitioner's posterity, the petitioner's mother and father were joined in the state of holy matrimony at the time the petitioner was born to them, and all of his ancestors were joined in the state of holy matrimony as evidenced by the statement of original status and the affidavit of corporate denial, which is recorded with the Pinal County Recorder at fee number 2013-032373, and the pedigree charts that are attached thereto, that is now the unrebutted truth in public policy and may be viewed at their website. And Will Livingston ratified the Constitution for the United States of America on behalf of New Jersey as the petitioner's fourth great uncle, which means the petitioner's posterity is found in the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. And the petitioner is entitled to right of blood, and right of blood cannot be destroyed by any civil law, because all the laws of Congress after 1871 and all the laws of Texas after the Civil War are civil laws. The right of blood and kindred cannot be destroyed by any civil law, Bouvier's Law Dictionary, 1856 edition. And this court is operating under power which is derived from the petitioner, as posterity, as the maxim says, the power which is derived cannot be greater than that from which it is derived. Bouvier's Law Dictionary, 1856 edition, volume 2, page 127. Therefore, it's impossible for the petitioner to give the county of Montague or their bar member handlers or this court any authority over the petitioner, and the legislative inferior Supreme Court of the United States agreed when it said it's impossible to confer sovereignty which will extend over the petitioner. And this is McCullough versus Maryland. The sovereignty of a state extends to everything which exists by its own authority or is introduced by its permission, but does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state, they're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer a sovereignty which will extend over them. The petitioner is exempt from the county of Montague and the Pope's private bar guild, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. And the petitioner requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, which is the supreme law of the land, anything in the constitutional laws of any state to the contrary notwithstanding. And if anything, I should have added in, and all judges shall be bound thereby, that other part of that statement. But that's, I don't think it's fatal. I think they're interested. I think they want to do something here. Fictions of law. Fictions of law were invented by the Roman praetors under ecclesiastical canon law for the Pope's ecclesiastical city-states, that is now the Vatican, under the pretense of doing equity. And this is Bouvier's Law Dictionary, 1856 edition, volume 1, page 520, fictions of law, invented by the Roman praetors, who, not possessing the power to abrogate the law, were nevertheless willing to derogate from it under the pretense of doing equity. Fiction is the resource of weakness, when in order to obtain its object assumes as a fact what is known to be contrary to the truth. When the legislator desires to accomplish his object, he need not feign, he commands. Fictions of law owe their origins to the legislative usurpations of the bench. So think about it. So what they're saying is that when a judge recognizes a fiction, he's no longer a judge, he's a legislator. Fictions of law owe their origins to the legislative usurpations of the bench. The bench is the judge. That's what judges sit on. Bill of attainder, bill of pains and penalties. A judge becomes a legislator when dealing with fictions of law, which means a fake judge's legislative act is a bill of attainder, because a bill of attainder is a, quote, legislative act that applies to named individuals to inflict punishment without a judicial trial. And that's U.S. versus Lovett. Legislative act, no matter what their form, that apply to named individuals or easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. A bill of pains and penalties. A legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. Because judges hold office during good behavior, the judges, both the Supreme and inferior courts, shall hold their offices during good behavior. And judges in bad behavior or fake judges are engaged in fraud upon the court. Derogating common law. When a superior court of general jurisdiction undertakes anything in derogation of common law, it becomes an inferior court of limited jurisdiction for that proceeding only. It is familiar law that when special statutory authority and derogation of common law is conferred on courts with general jurisdiction, such a court of general jurisdiction becomes quad hoc a court of inferior or limited jurisdiction. Therefore, the courts that I was dealing with were inferior courts of limited jurisdiction. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for other purposes. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. Accordingly, where a court of general jurisdiction accords to carry out special power, decision made in exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its authority of its jurisdiction does not apply. Ecclesiastical Roman canon law. Judges dealing with the Pope's minor estate are the Pope's clergy. Yet still it becomes difficult to find set bounds to ecclesiastical ingenuity. That's papal ingenuity, folks. For when they were driven out of all their former holes, they devised a new method of conveyance by which the lands are granted not to themselves directly, but to nominal fiefs, to the use of the religious houses. That's the Vatican. Thus distinguishing between the possession and the use, and receiving the actual profits while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, that's the Pope, to be bound in conscience to account to assisticate use for the rents and emoluments of the estate. Well, that's taxes, folks. And it is to these inventions that our practitioners are indebted for the introductions of use, which is short for usufructs, and trusts, the foundation of modern conveyancing. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And engage in fraud upon the court in conspiracy with the bar members working for the County of Montague Roman Canon Law Municipal Corporation, when they issue a bill of pains and penalties against the petitioner, the named individual, to be accomplices to the theft of the petitioner's land by using ecclesiastical fiction of law, minor estate, sesticate usufruct, and the law of trusts, which are things and have no rights. Forced rendition. County of Montague Roman Canon Law Municipal Corporation converted the petitioner's land from the land of Texas to the Pope's owned and operated foreign United States District of Columbia by rendering by force the petitioner's land, even though the Texas tax code originating after the Civil War with an act defining what money and property is subject to taxation or exemption and the mode of listing the same on August 21st, 1876. Be it enacted by the legislature of the state of Texas that all real and personal property in the state, all property of corporations now existing or may hereafter created, and the property of all banks or banking companies now existing or may hereafter be created, and of all bankers except such as hereafter expressly exempted is subject to taxation, and all such property, the value thereof, shall be entered in the list of taxable property for that purpose in a manner prescribed by this act. Which is for corporate-owned property in Section 4, the term person, whenever used in this act or any other act regulating the assessment or collection of taxes, shall be construed to include firm, company, or corporation, and requires cash or its equivalent for their taxes, which means Federal Reserve notes. Market value means the price at which property would transfer for cash. As explained in the Catherine Phillips Notice and Demand, 06-1022, that was served on the County of Montague, that shows taxable land is used for the production of income. Rendition. Tangible use for the production of income. Rendition originated with section on the Act of the Legislature of 1876. All property shall be listed or rendered in the manner following. First, every person of full age and sound mind being a resident of the state, which is corporate property, which means the petitioner's land fails to qualify for rendition, as explained in the Notice and Demand, that was served on the County of Montague because income is corporate profits. And this is emphasis in the original. I looked up this case, and the bold and underlining is in the original. It becomes essential to distinguishing between what is and what is not income, according to truth and substance without regard to form. Congress cannot, by any definition it may adopt, conclude the matter, since it cannot by legislation alter the Constitution from which it derives its power to legislate. and which within those limitations alone that power can be lawfully exercised. Income is derived from capital, the gain derived from capital. Here we have the essential matter. Not a gain accruing to capital, not a growth or increment of value in the investment, but a gain, a profit, something of exchangeable value severed from the capital, however invested or employed, and coming in or being derived, which is received or drawn by the recipient for his separate use and benefit and disposal. That is income derived from property. Nothing else answers the description. The Pope's ecclesiastical city-states in Italy. So this actual text of this certiorari is 40 pages. They won't let you make it more than 30 pages. And we are now on page 13. After the collapse of the Roman Empire, the Pope was absolute monarch of a group of ecclesiastical city-states on the Italian peninsula. Papal or Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, between Tuscany, Modena, and Lombardy on the northwest and Naples on the southeast. Population in 1833, 2,742,000. Rome, capital Rome, population 153,000. Government and elective monarchy, the Pope for the time being the absolute sovereign with the consulting assembly of cardinals. Rome, the capital of the Pope's territories and of Italy, and anciently the Milrus of the Roman Empire. With the law being Roman law is also called canon law, ecclesiastical law, municipal law, and civil law, the laws of the municipia or dependent states. Civil law or municipal law is that which every sovereign kingdom has appropriated for itself. The appellation of municipal was originally confined to the laws of the municipia or dependent states. Canon law, body of canon law, collection of ecclesiastical rules, definitions, constitutions taken from ancient councils, writs of the fathers of the church, ordinances of the Pope. This law modeled according to the form of the civil, contained in 3 particular volumes: the decrees of Gratian, the Decretals, and the Sextum. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. And civil or Roman law is also called canon law. The civil or Roman and canon law, though they are not perhaps to be deemed proper parts of the written law, have undoubtedly had the greatest influence in Scotland. And the Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in the year 1870, a year before the Pope's 1871 municipal corporation was enacted by Congress at 16 Stat 419. King John gave the kingdoms to the Pope. In the year 1213, King John gave the kingdoms of England and Ireland to Pope Innocent III and agreed to rent them back for 1,000 marks sterling per year. And this is Tomlin's Law Dictionary. And not long after this, by general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. With the concessions of England to the Pope, 1213. We will establish a perpetual obligation and concession. We will establish that from the proper and special revenues or aforesaid kingdoms, for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks, 700 namely for the Kingdom of England, 300 for the Kingdom of Ireland. And that's concessions of England to the Pope, 1213. Google it. You can pull that up all day long. which means the Pope owns the kingdoms of England and Ireland, now known as the United Kingdom, the Crown, and the City of London. The Cestui Act of 1666 caused the War of Independence. The Pope's dependent city-state, the City of London, called the Crown, created the Cestui Act of 1666, and this is that Tomlin's Law Dictionary definition again, who was held by the courts of equity, then under the direction of the clergy, the Pope, to be bound in conscience to account to a Cestui use for the rents and emoluments of the estate, which means the Pope's clergy were the judges in the ecclesiastical municipal law courts, which is what precipitated the War of Independence, as evidenced by the causes and necessities for taking up arms issued by the Continental Congress in the year 1775. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, instead thereof publish and order the use and the exercise of the law martial. For altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us. Despotism is dictatorship, folks. And the organic law of the Declaration of Independence shows it was listed as reasons for the Declaration of Independence from the tyrant, the Crown of England. This is only some of it. The Declaration of Independence is basically a list of grievances. He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, altering fundamentally the forms of government. He's abdicated government here by declaring us out of his protection and waging war against us. And that's the Declaration of Independence, because when we say he's combined with others who subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, the others is talking about the Pope, and the foreign jurisdiction is the Pope's ecclesiastical Roman civil law, and the definitive Treaty of Peace in 1783. In the preamble, it says King George was arch-treasurer and prince-elector of the Holy Roman Empire, evidencing the Crown of England is owned and operated by the Pope, and as arch-treasurer and prince-elector of the Holy Roman Empire, he's authorized to make peace on behalf of the Pope, which is also why thousands of people were fleeing Europe at that time, because of the Pope's tyranny there, as talked about in John Locke's 2 treatises of government. Tyranny is the exercise of power beyond right, which nobody can have a right to. And this is making use of power anyone has in his hands, not for the good of those who are under it, but for his own private, separate advantage. When the governor, however entitled, makes not the law, but his will the rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. 'Tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that. For wherever the power that's put in any hands for the government of the people and the preservation of their properties is applied to other ends and made use of to impoverish, harass, and subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. And that's John Locke, 2 Treatises of Government, Book 2, Chapter 18, Section 199 and 201. With the Spanish Inquisition, an inquisition is one way of proceeding in ecclesiastical courts, and other inquisitions and oppressions they routinely engaged in to enrich the Vatican. The use of information has a long history. For example, the reign of Henry VII had very oppressive uses made of them for something more than a century, as to continually harass and shamefully enrich the Pope's crown. Courts ecclesiastical are those courts which are held by the king's authority as supreme governor of the church, for matters which chiefly concern religion, and the laws and constitutions whereby the Church of England is governed, diverse and memorial customs, our own provincial constitutions, and the canons made in convocations, especially those in the year 1603, much oppression having been exercised through the channel of these courts on persons charged with trifling offenses within their spiritual jurisdiction. and also why the petitioner's ancestors made the first article an amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because they did not want it happening here. When they're talking about the Pope's pretended jurisdiction and pretended offenses in the Declaration of Independence, and this is where it talks about it in the Declaration of Independence, he's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation for transporting us beyond seas to be tried for pretended offenses. They're talking about the Pope's ecclesiastical Roman canon civil law. Canon law is the body of Roman ecclesiastical law relative to such matters as the Church either has or pretends to have proper jurisdiction over. Canon or body of canon law, collection of ecclesiastical rules, definitions, and constitutions taken from ancient councils, writings of the fathers of the Church, and the ordinances of the popes. This law is modeled according to the form of the civil, contained in 3 particular volumes, the Decrees of Gratia, and the Decretals, and the Sextum. And there are lots of references in old law dictionaries to the Pope's pretended jurisdiction. Jesuits born in the king's dominions and ordained by the pretended jurisdiction of Rome, remaining in England or coming from beyond sea into this kingdom and not submitting to some bishop or justice of peace within 3 days. So they had to basically, who knows,
check in, like when you went to the board, when you were sailing, you would have to have,
right?
well, you have to do that within 24 hours, but you have to check in.
Right. The oath of supremacy is principally calculated as a renunciation of the Pope's pretended authority. The Pope's private bar guild. The Pope's clergy operate their ecclesiastical Roman civil law courts with the private bar guild, with BAR being acronym which stands for British Accredited Regency. Regency is the office of jurisdiction of a region or body of regents, a government or authority by regents, the period during which a region or body of regents governs. Because the Pope's private bar guild clergy are appointed by Inns of Court. Inns of Court, there are certain private unincorporated associations in the nature of collegiate houses located in London and invested with the exclusive privilege of calling men to the bar, which is located in the Pope's dependent city-state located in the city of London, originally called the Kingdoms of England and Ireland, now known as the United Kingdom and the Crown, since concessions of England to the Pope, 1213, which means all private bar guild clergy members are foreign agents of the Crown, the Pope, which is why they're here under the civil laws of Congress, foundation of the Federal Bar Association under the Code of Law for the District of Columbia, now known as Title 35, USC 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945, 59 Stat 669, and King George approved the definitive Treaty of Peace of 1783 as Arch-Treasurer and Prince-Elector of the Holy Roman Empire, evidencing he was approving it on behalf of the Pope, and Article 1 of the definitive Treaty of Peace, which is the only article still in force under the treaty collection, which makes it the supreme law of the land under Article 6, Clause 2, and because King George and his popes owned and operated Crown of England for himself, his heirs, and successors, relinquishes all claims to the government propriety, because propriety is talking about private businesses, which includes the bar, and is a violation of the definitive Treaty of Peace of 1783, Article 1, as supreme law of the land, excuse me, under Article 6, Clause 2, anything in the Constitution or laws of any state to the contrary notwithstanding. The Pope and the Civil War. The Pope was involved in the Civil War because the Pope's owned and operated Crown of England sent fleets of ships to attack Washington, D.C. and San Francisco in support of the Southern Confederacy, but the Russians sent fleets of ships to blockade the area in support of Lincoln. The judge in the lower court or private bar guild members is required by the civil laws of Congress, known as Title 28 USC 631, and have exposed themselves to be the Pope's clergy. In the year 1861, the southern states walked out of Congress, and Congress ceased to have a quorum and conduct business. On 15 April 1861, under emergency and necessity with executive authority, with Executive Order Number 1, at 12 Stat 1258, Lincoln ordered Congress to reconvene, and everything has been under executive authority ever since. The Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in the year 1870, the year prior to Congress's 1871 municipal corporation. And are now called Vatican City and the Holy See, and it continues to this day. This is the Lateran Pact, Article 4, 1929, sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes as pertaining to the Holy City, forbid any intervention therein on the part of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. The Pope's ecclesiastical Roman canon law, Sestque Ius, was brought into the United States first with the Pope's 1871 Roman Canon Law Municipal Corporation, 16 Stat 419, because Roman law, civil law, Roman civil law, and municipal law are convertible phrases, and because municipal law was the law of the municipia, or dependent papal ecclesiastical city-states. The Pope's Sestque V Act of 1666 was brought into the United States with the Code of Law for the District of Columbia in 1901, Chapter 854, an act to establish a code of law for the District of Columbia, the legal estate to be the Sestque Ius, which creates the presumption that you were dead. At Chapter 3, absence for 7 years, presumption of death, he shall be presumed dead, in any case wherein his death shall come into question unless proof be made that he was alive during that time, within that time. And the Pope's Uniform Commercial Code, private international law under Unidroit, but individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights, duties, and privileges of the artificial entity or association of which they are agents or officers, and they are bound by its obligations. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. The Pope's minor estate, Sestque Usufruct, now codified at 31 CFR 363.6, and are unconstitutional because Article 1 of the amendment requires Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the Pope's necromancy, Sestque Usufruct, which is now called a minor estate, is an entity because an entity includes the estate of a living person such as an incompetent or a minor. Entity means any owner of a treasury direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, professional limited liability company, trust, the estate of a decedent or the estate of a living person such as an incompetent or a minor. And a minor can be anyone over the age of 18 years who has failed to take control of the securities in their treasury direct account. Minor means an individual under the age of 18. The term minors also refer to individuals who attain the age of 18 years but has not yet taken control of the securities contained in his or her minor account. And puts you under trust law, which is a part of Roman canon law. Trusts are things and have no rights. You know, Roman canon law is everywhere nowadays. You know, the Bank Act, negotiable instrument law is part of Roman law. Uniform Commercial Code is Roman law. That's actually private international law. It's part of the Hague Convention on Private International Law. It's everywhere. The Pope's Sestque Ius, minor estate, is a fiction of law which was invented by the Roman praetors under the pretense of doing equity and owe their origins to the legislative usurpations of the bench. And the Pope's fictions of law are necromancy and satanic. And this is Deuteronomy 18:10-12. There shall not be found any among you that maketh his son or his daughter to pass through the fire, or that useth divination, or an observer of times, or an enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all that do these things are an abomination unto the Lord, because these abominations the Lord thy God doth drive them out from before thee. and puts you under the Commerce Clause, Article 1, Section 8, Clause 3, violating Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as by cession of particular states and acceptance of Congress become the seat of government of the United States. There's two national governments, one under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. They use fraud and deception to assault people with a quasi-contract, a fake contract, a sumpsit. In its origin, an act of tort, the sumpsit was soon transformed into an action of contract, becoming afterwards a remedy where there was neither tort nor contract. Based at first upon an express promise, it was afterwards supported upon an implied promise and even upon a fictitious promise. Introduced as a special manifestation of the action on the case, it soon acquired the dignity of a distinct form of action, which superseded debt, became concurrent with account, with case upon a bailment, a warranty, bills of exchange. Those are all commercial words, and competed with equity in the case of essentially equitable quasi-contracts. Both in English and Roman and English law, there were certain obligations which were not in truth contractual, but the law treats as if they were. They're contractual in law, but not in fact, being the subject matter of this fictitious expansion of the sphere of a contract to cover obligations which do not in reality fall within it. If you nail these judges down, any of these judges nowadays, if you nail them down, they'll tell you it's quasi-criminal, which means it's a quasi-contract, which requires the Pope's fiction of law, minor estate. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. Because under the Commerce Clause, the boundaries of the Pope's District of Columbia and through their plenary power nationally covers those citizens, even in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. Because plenary power is a dictatorship under the Pope's Roman canon law, fraud upon the court, the judges in the lower courts are tyrants operating as bought and paid for administrative legislative clerks masquerading as judges. The Pope's clergy under the Pope's canon law of trusts and bad behavior and fraud upon the court, which is non-judicial proceeding, because whenever statutes involved, the Pope's fake judge is actually a clerk masquerading as a judge as the Pope's clergy. It's the accepted rule, not in the state courts, but of the federal courts as well. When a judge is enforcing administrative law, they're mere extensions of the administrative agency for superior reviewing purposes, which means they're legislators engaging in legislative acts against the petitioner, the named individual, by using a minor estate, which is a fiction of law, was invented by the Roman praetors under the pretense of doing equity, and owe their origins to the legislative usurpations of the bench, which means the fake judge in the 97th District Court and the fake judges in the U.S. District Court for the Northern District of Texas acted as legislators, issued a bill of pains and penalties against the petitioners, which are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. And also Article 1, an amendment says Congress shall make no law respecting an establishment of religion, because it's from the Pope's Roman law, also known as canon law and ecclesiastical law. They're also bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. Like colonial days, they've imposed martial law rule, which is why we took up arms in 1775 with a bankruptcy emergency. It's an established fact the United States federal government's been dissolved by Emergency Banking Act. Roosevelt did that. He committed an act of treason by doing this too, by the way. Being bankrupt and insolvent. He basically turned the United States over to the Vatican, and they've been the enemy from the beginning. And so that's called treason. The abrogate the gold clause, dissolve the sovereign authority of the United States in the official capacities of all United States governmental officers, and departments, and is further evidence that the United States federal government exists today in name only. Since March 9th, 1933, notice the dates, March 9th, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's U.S. Senate Report number 93-549, dated November 19, 1973. And nothing has changed. Martial law rule is a law of emergency and necessity. This is Ex parte Milligan. There's three kinds of martial law. There's full martial law when actually invaded by a foreign enemy or insurrection. Troops are put on the street. Martial law proper is the law of the armed forces. A private sergeant tells a private what to do. It's enforced by court-martials. Martial law rule is the law of emergency and necessity. Used during peace times, can go on indefinitely. Private bar guild is here to enforce the martial law rule for the Pope, and the Pope's bar guild clergy members on the bench tell you I can do anything I want in this court. This is a war over the intrusion of the civil law over the common law. Court in Diamond v. Harris calls civil law, statutory law, superior equity. It's difficult to see how the courts of the state are to ignore the common law as a rule of decision when it's made so by statute and adopt a civil law even though it had the merit of superior equity. In the meantime, the civil law was a form of law imposed by the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on its head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. And so what they're saying, and you see this all the time, is that because normally equity is supposed to follow common law, okay? Equity is found in the Bible. And so equity is supposed to follow common law. But when you have martial law supersedes and replaces common law. It talks about that in the causes and necessities for taking up arms right here. So when you have martial law, there is no common law, and equity can do anything they want, and the judges will even tell you that. I can do anything I want in this courtroom. Because normally equity follows common law, which is taken from the Holy Bible, but after the Pope's martial law rule, there is no common law because it's superseded and replaced, as also talked about in the causes and necessities for taking up arms. Statutes have been passed, extending the courts of admiralty and vice-admiralty far beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish the order and use of the law martial. And the law of the land in America is common law because of our Christian religious beliefs. Every system of law known to civilized society generated from or had as its component one of three well-known systems of ethics: pagan, Stoic, or Christian. Common law draws subsistence from the latter, that's Christian. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic frictions and by which all legal controversies are settled, which makes it satanic. And the Pope's private bar guild clergy Satanists are using the Pope's ecclesiastical canon Roman civil law of Capitis Diminutio Maxima, the highest and most comprehensive loss of status, when he became a slave. Under the Commerce Clause, Article 1, Section 8, Clause 3, to assault people with their penal action for breach of quasi-contract, which is a fake contract. Penal action is an action on a penal statute, an action for recovery of penalty given by statute. Where an action is founded entirely upon a statute, the only objective is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty, in their strict and primary sense, denote a punishment, whether corporal or pecuniary. We're going to talk about pecuniary here in a minute. Imposed and enforced by the state for a crime offense against its laws. The noun penalty is defined forfeiture or forfeited for non-compliance with an agreement. It's breach of contract, breach of quasi contract. They're assaulting you with this fictitious contract and saying, and so then you got to go to jail because you breached this fictitious contract, which is pecuniary punishment for noncompliance with agreement, all tied to the Pope's ecclesiastical canon Roman civil law with the Pope's quasi-contract ecclesiastical pecuniary cause, such as arise either from withholding of ecclesiastical dues or the doing or neglecting some act relating to the church, whereby some damage accrues to the plaintiff towards obtaining satisfaction for which he is permitted to institute a suit in the spiritual court. Such, for instance, are the subtracting or withholding of tithes from the parson or vicar, and the non-payment of ecclesiastical dues to the clergy, as pensions, mortuaries, compositions, and the like. To populate the Pope's prisons by selling people into slavery. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights, except those which the law and its humanity affords him. He is, for the time being, a slave of the state. The Pope's clergy in the lower courts are subjecting the petitioner to their satanic religious ceremony with their fraud, lies, deception, necromancy, and idolatry in violation of Article 1 and Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, that the Pope's Federal Bureau of Investigation refuses to investigate, and the Pope's United States Attorney refused to prosecute with their weaponized Department of Justice that should be renamed Department of Just Us, because they intend to engage in war crimes in violation of Article 3 of the Geneva Convention relative to the protection of civilians in time of war of 1949, by taking reprisals against the petitioner for political beliefs and religious beliefs, evidencing that the Pope's owned and operated United States has no intention of prosecuting anybody for war crimes unless it happens to fall within their political agenda. Trump even paid off the Pope when he commuted Roger Stone's penance sentence, which was changed into a sum of money to be applied for pious uses. Penitentiary is a penitent or ordainer of penances, a place for penitence. Penance is a punishment imposed for a crime by the ecclesiastical laws. It's an acknowledgement of the offense. Penance may be changed into a sum of money to be applied to pious uses called commuting. He commuted Roger Stone's sentence. And because of the administrative legislative proceedings under the Pope's Roman civil law, there are more people in prison in Texas as a percentage of the population than there are in communist China or the Soviet Union or the worst dictatorship in history. The Innocence Project estimates that 60% of prisoners are innocent, but it's such good business for the Pope and their ecclesiastical Roman civil law so-called courts, which is one of the grievances of the organic law of the Declaration of Independence. He's plundered our seas, ravaged our coasts, burned our towns, destroyed the lives of our people. All of this has been planned and orchestrated from the Pope from the very beginning of this nation. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And that's Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. Because the Pope was responsible for the War of Independence, and the Pope is responsible for what's happening today. The Pope owns and operates the 1871 Municipal Corporation. The Pope now owns and operates the bankrupt 1871 Ecclesiastical Municipal Corporation as 16 Stat 419, because when any corporation goes bankrupt, it gets seized by the creditors, as evidenced by the Roman Achaea military staff that's carried in battle by all Roman commands and planted on all conquered nations, that is sitting on the right side of the speaker's podium, and the two Roman fascia bundle of rods bound into a weapon symbolizing under the rule of a single man that are on the wall on each side of the speaker's podium in the U.S. House of Representatives, which is also why, as Speaker of the U.S. House of Representatives, Nancy Pelosi told a member, quote, "We can't read this bill until after we pass it," unquote, because she was taking instructions from her Jesuit handlers, all of which evidences the fact that the 1871 Municipal Corporation, 16 Stat 419, currently operating in the District of Columbia, is the Pope's dependent city-state. See the image. Below, see the image below. The Vatican's Pope Francis recently issued an apostolic letter and jurisdiction of judicial authorities of Vatican City, state, and criminal matters that talks about concurrent jurisdiction in other states, which means other papal states like the District of Columbia and the City of London and the United Kingdom Crown. And there's the Speaker's podium in the U.S. House of Representatives. There's the two Roman fascias right there, one there and one there. And this is the Roman Achaia military staff that's planted on all conquered nations. And this is the apostolic letter. When the same matters are prosecuted in other states, the provisions enforced in Vatican City State on concurrent jurisdiction shall apply. 1st of September 2013. Which means the Pope's ecclesiastical canon law is brought into Texas with the Commerce Clause, Article 1, Section 8, Clause 3, and the Pope's minor estate, fiction of law, and the Pope's fictitious quasi-contract. And the Vatican's Pope Francis came and addressed his own and operated Congress on 24 September 2015, and the Pope's private bar guild clergy members are assaulting people like the petitioner with the ecclesiastical fiction of law, minor estate, sestike usufruct, trust, necromancy, with presumptions of jurisdiction, presumptions of the office of trustee because of the sestike usufruct minor estate, and presumptions of suretyship. The petitioner has served literally thousands of registered mail notice and demands in an effort to defeat those presumptions, to petition the government for redress of grievance and exhaust administrative remedies, which is why they've targeted the petitioner with their targetedjustice.com website agenda. As posterity, the petitioner is entitled to common law, not Roman canon law, by right of blood, as described in Article 6, Clause 2 of this Constitution for the United States of America, the supreme law of the land, and is also found in the Judiciary Act and the Judicial Code of 1911. Under Article 6, Clause 1, all debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against under this Constitution as under the Confederation. Because the Northwest Ordinance was adopted just 3 months prior to the Constitution, which defines the nature of jurisdiction and federal territory in Section 14 of the Northwest Ordinance, Article 2, the inhabitants of said territory shall always be entitled to the benefits of the writ of habeas corpus, trial by jury, judicial prigs, according to the course of common law. Because the law of the land phrase is convertible with the phrase common law, and common law and law of the land has always been here long before the government was here. And this is Hale versus Hinkle. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state. Antecedent means before. And because the maritime codes only apply on the high seas and up to the high water mark or the first bridge of any navigable river in the District of Columbia or any federal enclave under Article 1, Section 8, Clauses 17 and 18. The petitioner has been very vociferous about being posterity as found in the preamble, a living man, a living soul in every document filed into every case, evidencing the prejudgment on behalf of the Pope's private bar guild members on the bench, the Pope's clergy and their Vatican handlers, because it fails to matter what the petitioner does or says. This case was prejudged from the beginning using trust law by the Pope's clergy, because trusts are things and fail to have rights, and the Pope's clergy can do anything they want. The petitioner demanded the County of Montague produce a bona fide contract or be guilty of the felonies in the Catherine Phillips notice and demand, and they failed to produce any evidence of a bona fide contract or even answer. And the Pope's clergy in the lower court failed to produce a contract. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to the license. All courts are required to presume that no contract exists because none have been produced to this day. The resolution of Congress says that because we have a Republican form of government, we are all sovereign citizens, as evidenced by House Joint Resolution 183, dated May 3rd, 1940, says in the preamble, whereas desirable that the sovereign citizens of our nation be prepared for their responsibilities and impressed with the significance of their status in our self-governing republic. and as affirmed by Harold M. Stevens, Chief Judge of the United States Court of Appeals for the District of Columbia Circuit, in his article on the American Bar Association entitled Citizenship, the Real Profession of Every American. If our sovereign citizens are not informed upon such subjects, how can they intelligently participate in the determination of pertinent national policies? Which means the County of Montague corporate ringleaders under Roman canon law may be engaged in treason to the Republic, as well as the private bar guilds may be giving aid and comfort to the enemy in a time of war, because we are attacked by the communist Chinese, the Venezuelans, the Cubans, the Serbians, and others in the 2020 election theft and a fake pandemic and a forced medical experiment with their communist agenda to implement the first plank of the Communist Manifesto, the abolition of private property rights with their theft of the petitioner's land in this case. The County of Montague, Ecclesiastical Municipal Corporation, and the private bar guild members, as well as the weaponized Federal Bureau of Investigation, as well as the weaponized Department of Just Us, and the Obama administration and the Biden administration are making war on we the people and the Republic, just like the Pope's crown did, which precipitated the War of Independence. He's abdicated government here by declaring us out of his protection and waging war against us. The communists and the FBI made war on the Republic by using sovereign citizen as a buzzword for persecution and prosecution, and then by circulating numerous news articles stating all sovereign citizens are terrorists, as found in an ABC News article entitled Sovereign Citizens, Terrorism Assessment Warns of Rising Threat from Anti-Government Extremists, and in RT.com entitled Sovereign Citizens Seen as Top Terrorist Threat by U.S. Law Enforcement by Brian Blanco, 5 August 2014, and numerous other articles saying they intend to murder any sovereign citizen without a trial, without due process by Obama's order followers, and then they proceeded to do exactly that. They issued the Pope's clergy in the lower courts. They issued the findings, conclusions, and recommendations of the United States magistrate judge, and then approved it. And they're required to issue a findings of fact and conclusions of law, which means it has nothing to do with facts or law, which means they're deliberately and calculatingly legislating from the bench for their bill of pains and penalties and expose themselves to be the Pope's clergy. They in the lower courts have presumed the petitioner is a minor estate. The power to create presumptions is not a means of escape from constitutional restrictions, in spite of the fact the petitioner says he's a living man and fails to be their sesticate usufruct on everything under penalty of perjury and has for many years. Their bill of pains and penalties are unconstitutional acts and a nullity. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. They unfiled 78 criminal complaints that the petitioner filed into the case in support of their weaponized Federal Bureau of Investigation, refusal to investigate them, and support of their targeted justice.com agenda and weaponized Department of Justice, Just Us, to refuse to prosecute felonies against targeted individuals like the petitioner in the hope the petitioner will exercise the right to resist their unlawful arrest and their unlawful theft of the petitioner's land and their forced slavery with lethal force if necessary, so they'll have an excuse to murder the petitioner, and they say they killed another sovereign citizen terrorist in support of their war crimes agenda to take reprisals against anybody who thinks they have rights for their political beliefs, in support of their communist handlers to eliminate private property rights, all of which is in support of the Pope's private bar guild and their Vatican handlers, who love satanic blood sacrifices for their Roman cult god Baal, so they can pillage the fake money from the Treasury Direct account under GlennWinningham Fern under the Hague Convention concerning the international administration of the estates of deceased persons, concluded 2 October 1973. And the petitioner is not suicidal, but if the petitioner does turn up dead, this is deathbed testimony. Therefore, whether they enslave the petitioner or kill the petitioner resisting their slavery, either way, it's a win-win-win scenario for the Pope. The Pope's clergy evidently intend to perjure their oaths in support of the supreme law of the land under the Pope's Code of Law for the District of Columbia, now known as the Pope's United States Code 28 U.S.C. 453, and demonstrate they have no intention of being neutral or unbiased. And they cannot use their presumptions to escape their oath of office requirements under the supreme law of the land. Petitioner has filed bar grievances against 98 of the Pope's private bar guild clergy, some more than once. They've all been dismissed as an inquiry. They were all appealed to the Pope's Board of Disciplinary Appeals, and they were all dismissed again. The petitioners filed judicial complaints against more than 50 Texas judges and the State Commission on Judicial Conduct, some more than once, and they've all been dismissed, 25 of them on the same day. Only an Article 3 court can make decisions about life, liberty, or property, which has been previously assumed by numerous times by the legislative inferior courts. Therefore, they're acting with no authority and maliciously. And both the 97th District Court and the Northern District of Texas failed to be Article 3 courts because government employees like Catherine Phillips and their County of Montague accomplices do not get an Article 3 court. That's under National Mutual Insurance Company versus Tidewater Transfer Company, evidencing that even though they were not possessing the power to abrogate the law, were nevertheless willing to derogate from it under the pretense of doing equity in support of their intent to be a legislature with their legislative usurpation of the bench and their unconstitutional bill of pains and penalties because the County of Montague Ecclesiastical Municipal Corporation is the Pope's owned and operated ecclesiastical municipal corporation called United States, which is operating in the District of Columbia under the Commerce Clause. And they're making the petitioner the Pope's minor estate. Therefore, they fail to be an Article 3 court, but are instead an Article 4, Section 3 court. And are not competent to make a ruling about the petitioner's life, liberty, or property, which includes land. And their decision is a void judgment, and the judges in the lower court have exposed themselves to be the Pope's clergy, and the petitioner filed a notice of void judgment into the case. Because the Pope's clergy in the lower courts seem to be always finding an excuse to ignore their oaths to the supreme law of the land, Article 6, Clause 2, the petitioner has been forced to file an affidavit of life and mandatory judicial notice of 12 presumptions, true copies of which are attached hereto in the appendix at tab 10 and tab 9, respectively. But the petitioner doubts it will make any difference because they're the Pope's clergy and have no interest in justice and are instead engaged in just us for their Vatican handlers and our Satanists. You're of your father the devil, the lusts of your father you will do. He spoke not in the truth. There is no truth in him. When he speaketh a lie, he speaketh of his own, for he's a liar and the father of it. But the fearful and unbelieving and abominable and murderers and whoremongers and sorcerers and idolaters and all liars shall have their part in the lake which burneth with fire and brimstone, which is the second death. The writ should be allowed because it is nationally important, will affect almost everybody and all governmental entities in the country. The Pope's minor estates are in place for almost everybody, and almost all governments have established the Pope's municipal corporations, and the Pope's bar, British accredited regency, is a source of corruption because of their lack of Christian common law ethical standards and violation of the definitive Treaty of Peace of 1783, Article 1, which is the supreme law of the land under Article 6, Clause 2. That's the reasons for granting the writ. The Pope's 1871 Ecclesiastical Municipal Corporation, operating under Roman canon law in the District of Columbia, is unconstitutional, as well as the Pope's minor estate, now codified at 31 CFR 363.6, and the Pope's private bar guild foundation of the Federal Bar Association and all of its subsidiaries in the various states. Because they're all violations of Article 1 and Amendment, Congress shall make no law respecting an establishment of religion and prohibiting the free exercise thereof, because there are laws respecting the Pope and the Vatican and the Holy See. And they're subjecting the petitioner and all the people they're dealing with to their satanic religious ceremony, with their fake court cases, with their fraud, deception, lies, necromancy, slavery, idolatry, and human trafficking. And the Pope's Foundation for a Federal Bar Association under the Code of Law for the District of Columbia, now known as Title 35, USC 70501 through 70512, is a violation of the definitive Treaty of Peace of 1783, Article 1, which is the supreme law of the land under Article 6, Clause 2. The findings, conclusions, and recommendations of the United States Magistrate Judge and the ruling of the 97th District Court are each a bill of pains and penalties, legislative usurpation of a bench against the named petitioner, and violations of the Bill of Attainder clauses, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. The County of Montague, Roman canon law municipal corporation, and conspiracy with the Comptroller of Texas, the private bar guild in Texas, the attorney with the rank of general, are bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. Signed and sealed in red ink on the land of Texas. Fails to be dead or lost at sea, has never been dead or lost at sea, fails to be a surety for the Pope's minor estate, fails to be representing the Pope's minor estate, has never knowingly or willfully represented the Pope's minor estate. And then there's the appendix. Okay, so that's about it. Does anybody have any questions?
Well, I hope that brings you a lot of equity.
Oh, I was going to show you the docketing letter now.
I'd tell you this, Glenn. I want to thank you for your service. I have high hopes for you if they hear this. My prediction is they won't. They're going to try to bury it. I think that they're captured, but I think that if more people do what you're doing, that maybe things will change. But I just, as much as I want to believe, I just don't have faith anymore.
I understand your concerns. Let's look at the docketing letter, because I think that says a lot. I think that I really like what Trump is doing. Then there's all sorts of people that are just tearing a strip off of him because of this or that war with Iran, who knows what. They're just coming up with all sorts of reasons why they don't like what he's doing. But there's some things in here. So this is the docketing letter, and I have to send this to the council. And they have to respond by the 25th of March, which isn't very far away. It's like 20 days. So beginning November 13th, parties represented by counsel must submit filings through the Supreme Court's electronic filing system. Paper remains the official form of filing, and electronic filing is in addition to the paper filings. So that's why I'm just going to do paper, and that's all I ever did. And it says parties represented by counsel. That means the lawyers have to do that shit. And the reason I don't want to do it is because in order to do it, you have to give evidence against yourself. You have to give credit card. Okay, think about it. Credit card means that they're getting a social security number. They're getting that credit card number. They're getting a social security number. That's evidence that you're a federal U.S. citizen. And so I don't give them any of that stuff. And so I make sure that it's all paper. And I object to all of it, to any time they want it. Like you saw what I did with the impecuniosity. Now, also says here, this didn't used to be in there. And this is unless the Solicitor General of the United States represents the respondent, a waiver form is enclosed, should be sent to the clerk only in the event you do not intend to file a response. So the point being is the Solicitor General is going to respond no matter what. And that was not the case before. That statement wasn't in there before. And this is the 6th time I've been to the Supreme Court. So I think they really do want to hear this. I think remote viewers, Dick Allgaier, there's remote viewers. I've seen remote viewers that said they saw Congress adjourning for the last time. I think that maybe this is what is going to cause it. I don't know, but this could certainly cause it. I don't know. But at any rate, you have to do what you have to do. And so they're telling me here that I don't have to send a copy of this. This is the waiver. And so that's for lawyers. Anybody that wants to waive their right to respond. So remember, I understand your skepticism there. That's for sure. I mean, there's certainly good reason to be.
Yeah, like you said, I had what I thought was mandamus. They didn't have discretion. It was ministerial duty. I pointed out the Supreme Court where it was a ministerial duty, and there wasn't discretion, and it was still denied. And maybe I could have done better. Certainly, I'm certain I could have done better, but I shouldn't have to do better. I mean, it was obvious on its face, but just
Well,
like yours
what
is.
state are you in?
Alabama.
Yeah. Some states are more corrupt than others, there's no doubt. I mean, that's why we need to get rid of this bar, quite frankly. The bar is the source of all of our problems, or it's certainly a major source. So these respondents right here, Chad Yarborough, Leah Simonton, Janet Yellington, Jonathan R. Owsley, Tim Harrelson, that's the Montague County tax assessor. No, appraisal district. He's the guy that they're saying, I'm guessing he's the guy that forced rendered my property. Jonathan R. Elsie is a lawyer and that they assaulted me with. And so good. I'm glad he's still on there. These ones I know are on there for sure. And State Bar of Texas, this is all, I mean, that's cutting to the chase. They went and the Court of Appeals removed a bunch of people, I'll tell you right now. But this is the ones that that they left. At least these. I think there might be other ones too. But so, who knows? It's hard to figure all that stuff out sometimes. But I understand your. I mean, I've had 5 of them that basically what they did is they waived their right to respond, and then the clerk sent me a letter, said the court has dismissed the case, and after it was accepted, and so, but. Now they're not all going to waive, okay, because that Solicitor General is going to have to respond, and the Solicitor General is going to represent Chad Yarborough, Leah Simonton, and Janet Yellen. Okay, those 3 are going to be represented by the Solicitor General. So he's going to have to respond for them.
The Solicitor General can waive the response, and if he that'll be your clue. If the Solicitor General waives, that's an indication that the Supreme Court's going to deny the certiorari if they waive. So if he doesn't waive and he responds, then that's a great sign. So let's pray that happens. I mean, like I said, I really want to believe. I want to believe that you're going to be successful. I mean, we know everything you state is true and factual. I just I've gotten to the point where now I'm going after them with the taxes because it's like these courts are captured. But I yield.
I understand, but I think Trump is making some changes, and that docketing letter specifically says that the Solicitor General has to respond. So I think that.
But they can respond with a waiver of response, like they did with me. It ordered the Solicitor General to respond to mine, and the Solicitor General responded with waivers.
Who was president then?
Trump. It wasn't that long ago. I mean, you're only talking about 3 months ago.
Oh, really?
What do
Well,
you mean when you say waivers?
They can waive a response, meaning they're not responding
Why can't we
unless
do that?
unless ordered so by the court.
Oh, so Glenn, was this, I missed the very beginning. Is this a writ that you wrote, or is it a petition, or?
the Supreme Court accepted my petition for writ of certiorari.
Oh, wow. So like the big Supreme Court or your state?
U.S. Supreme Court.
Wow, that's amazing. Congratulations.
I think they want to hear this. I think this is something that they want to hear. And I can tell you for sure that I told Trump, I sent something to Trump about this too. And so Trump is aware of it, and that Solicitor General does what he wants. And so I think that they want to, I don't know what's going to happen. But I guess we'll see.
Well, that's great. Congratulations. I did a right before Thanksgiving, I mean, I just actually got evicted this week at gunpoint by 8 sheriffs with no writ, no signed by the judge, nothing signed by the clerk, wrong address, everything, gunpoint. Anyway, what I was going to say was that I did a writ just to my state Supreme Court of mandamus, and interesting. Everything just went silent. I mean, I thought I was just ordering them to make the lower court do something, but the lower court, the judges and the clerk, I guess they hired an attorney or something, and I knew nothing about it because I can't. I didn't even have access to the docket or anything. They don't put the appellate cases or the writs in public. So anyway, basically all this stuff that I said, well, one of them was that, the clerk didn't have an oath and she had signed all these summons and she doesn't have the requisite digital signature on file, and I had all my evidence and stuff. And I think they honestly just took, you know, their 3 or 4 months and cleaned up the mess and then sent me a letter of it's all moot. And then they denied my writ, but they cleaned up the mess of everything that I had, said. However, it affected my substantive rights, obviously. And with the clerk not, basically her office was vacant, and having served these summons on me to begin with like 2 years ago. And they did go and they cleaned her mess up and they changed her name on all the public websites and stuff like that. And but then what was interesting, and I think I have a little something here, and I'd love to hear your feedback, Glenn, because you're such an expert in this. But so they actually removed all the summonses out of my foreclosure case because that was part of the deal. This started with a clerk's signature that's invalid, and she has no oath of office, and she's signing documents with a name in a completely different capacity. And yeah, they just removed all of those summonses. They're gone. I mean, there's a docket entry that says summons, but there's no documents attached to them. Do you think I have anything? I mean, can I go in and say, look, there's no summons. There was never a court case started. I mean, I've already put in 20 void judgments, but I mean,
Yeah, I know it's
yeah,
extremely corrupt.
yeah,
And really, in my opinion, I think what it's going to come down to. Have you ever seen pictures of those hanging trees?
yeah,
They've got like 20, 30 people hanging underneath them.
yeah.
I think it's going to come down to that. I really do.
Well, I don't know. I don't see that. I just don't see it happening. They are above the law. There's no accountability, nothing. I mean, I went straight into the judge that did my eviction, and I walked straight up to his stupid little bench, walked in his courtroom, and well, and I handed it to him, the writ. I said, 8 sheriffs just held me at gunpoint, and I walked out with the clothes on my back and my dog. I said, and this is not even signed. He goes, well, we procedurally do things different now. We don't, I can put a digital signature on it's like a fax cover sheet. I said, this is not signed. I said, where's your oath of office?
No,
I don't
it's
know. I
supposed to
guess
have
maybe
a
you can
court
shut
seal.
down in the clerk's office.
It's supposed to have a court seal too.
No, it doesn't have a signature, a seal, nothing.
So at any rate, the reason they're able to do all this, and Trump knows this, and that's why he's trying to get us back on the gold standard, is because of the fake money, number one, and it's because of the Roman law. And that's why I filed this, because if we can get this, if that minor estate is ruled as unconstitutional, which it clearly is, then so the question I have, I think it's a victory. I think it's definitely a victory. The question is am I going to get like it's a home run already? I could get one ruling in my favor or up to three. Okay, if I get one, I think the minor estate's clearly unconstitutional, and I think the bar is clearly unconstitutional. It's a violation of the um, um, definitive treaty of peace. But if I get all three, that will be huge. I think I will. And I think what'll happen is it might even be a unanimous decision, which would be unprecedented. I think it'd almost have to be because then, what'll happen is because that's the remote viewers, what they saw was they saw congressmen adjourning for the last time, and they were sick. They were absolutely sick. They were puking up in the hallways. They were just sick. And so the only way I could see that happening is if all the judges said, yes, this is right. Because if it was down political lines, then they'd just be fighting amongst each other. You see what I'm saying? And so if that remote viewing was correct, and then I'm guessing that the way it would work is it'd have to be a unanimous decision or a near unanimous decision, so then the liberal ones and the conservative ones agree that they're unconstitutional. So at any rate, I guess we'll see. I've sent this to Trump. I can tell you that I've sent it at least once to Trump, and so I think that he's got it, and they've made some changes, and so I think I don't know what's happened in other cases or what the issues were that were being brought up, but I think that they want this, and they want to rule on it, and they're gonna. And so I guess we'll see. That's all. That's just my opinion, I guess you might say, but I think that's what's going to happen. So, anyways, so I suppose we ought to. I've been doing this for 2 hours now, so I guess we're about done. Thanks, everybody, and we'll talk again next week, same time, same place, same channel.
Hey, Glenn, quick question. When do they hear that? When do they see it? Or,
It could be
review
months.
it, or it could be months?
Oh yeah, for sure.
Okay.
Yeah, it'd be months. I would be surprised. I mean, I don't know. I'm thinking maybe this year. Maybe they'll hear it this year. It's hard to say.
Wow.
If not, sometime next year. It could be months. The case number is 25-6877. So that's a last year's case number, but so we'll see. That's all I can say. I think this is one they want to see. I think they almost have to, because there's a bunch of reasons why, and with Trump being in there, I think that guy that's the Solicitor General, I don't know, what he did on the last one or why or anything like that. But I'm asking questions that I think they want to answer. Anyways, We'll see you guys next week. Same time, same place, same channel.
Thanks, Glenn. It was good.
Thank you, Glenn.
Thanks,
Awesome.
Glenn.
All
Thank
right.
you for your service, sir.
All right. Take care. Hang in there. It ain't over.
Keep me updated.
I will.
So the fat lady sings.
Yeah, that's right.